So welcome to the Veterans Benefit Group webinar. This is an overview of veterans benefits. So some of the things we're going to talk about today are what benefits are available, what elements are of a successful claim, what to do if you get denied, and talk a little bit about the role of a lawyer. There'll be a chance for folks to ask questions. You can type in your questions along the or through the system here, and we will hold on to those. And if we get a chance at the end of the presentation, we'll go ahead and start answering those questions. So without further ado, I'm going to get started. Well, just a moment, a little technical difficulty here, just a moment. Okay, I think our technical stuff has been fixed. So let me introduce myself. My name is Daniel Krasnegor. I'm an attorney. I'm in Charlottesville, Virginia. I started my job with the VA back in 1998. Back in 1995, I worked for the VA from 1995 to 1998. After that, I've been in private practice since 1998, first with another law firm, and I've been with Goodman, Donnelly from 2008 to the present. So that's who I am. I know we have a lot of folks out there. Some of you folks are clients, and I welcome you to attending this conference or this webinar. We've got some other folks who are probably not clients, and I welcome you as well. So again, the format for today, I'm going to do a general overview of veterans law. I'm going to go through a whole bunch of stuff really rather quickly. So if you do have questions that occur to you as we go along, just go ahead and send those to us, and we'll do our best to answer some of those. I'll make a quick note to say that I know a number of you probably have your own claims that are going on at the VA right now. Some of you are clients, some of you are not. If you have specific questions about your own case, and you are a client, go ahead and just get in touch with us through your case manager. We're happy to answer any questions you have. If you're not a client and you have questions about your specific case, we'll give you some information later in the presentation about how to get in touch with us. So today's webinar itself is not really a chance to ask your own questions about your own case. Okay, so first I'm going to go over a brief set of what kinds of veterans benefits are available to folks. The most common one that you'll see is called service-connected disability compensation. What is that? That is a monthly tax repayment that is paid to a veteran who incurred a disability during service. The amount that you receive, if you receive service-connected disability, is based upon how severe the condition is. Another type of benefit that's available is called non-service connected pension. A non-service connected pension is paid to a veteran who served during war if they're not able to work any longer. And that benefit is not based upon your service-connected disabilities. It can be based upon any problem that you have. There's something that you may have heard of called aid and attendance. Aid and attendance is not really its own benefit. It's really just a higher level of non-service connected pension. So it's an added monthly amount that you can get. Some other benefits that are out there are what are broadly termed survivors benefits. Some of these include dependency and indemnity compensation. That's a benefit, a type of compensation paid to a widow or a widower, and sometimes to a disabled child or a minor child when the veteran themselves dies from a service-related condition. There's also a type of pension that can be paid to a survivor, and that is, again, dependent on whether the survivor is able to work anymore, and those are pretty limited in who can receive them because a survivor who gets a pension must have a very low income. Some other types of benefits that are out there. I'm not going to go into these too much today, but I just want to mention that they exist. Vocational rehabilitation is a program that's available to veterans. VA medical treatment at VA facilities and sometimes at non-VA facilities is another type of benefit. A caregiver benefit, which is something that was recently established. That's a money paid to a caregiver for taking care of a disabled veteran. GI Bill, that's a general term sort of referring to education benefits. Sometimes these education benefits are paid to veterans. Sometimes they're paid to their dependents. Burial and funeral benefits are available to most veterans, and automobile and housing adaptations. Those are another set of benefits that are available. But again, I'm not going to go into those too much detail today. Okay, so next I'm going to go over very briefly how to make a claim with the VA. So one of the important things to know about the VA is since about 2015, in order to make a claim for any sort of benefit with the VA, you're required to use a specific form that the VA puts out. So you can find most of these forms online by going to www.va.gov. If you fill out the wrong form, the VA is supposed to tell you and give you a chance to fix it. But that's pretty much the easiest way to file a form. You can also file a claim by working with a veterans service organization. VSO is a term that refers to veterans service organizations. It also refers to a veterans service officer. These folks don't actually work for the VA, but they are free representatives and they can help you make a claim if you need to do so. Disabled American Veterans, the American Legion are some examples. Most states also have state employees who work with veterans in this capacity. So that might be sort of like, the Texas Veterans Commission's one example. The Virginia Department of Veterans Services, that's another example of a veterans service organization. So let's talk a little bit about what happens after you make a claim. With the VA, there's something called the duty to assist. The duty to assist requires that if you make a claim with the VA has to help you try and get together the information and evidence you need to win the case. So that means that they may get in touch with you. They may have you go to an examination. They may have you, make specific requests to you to get more information. All of this is sort of called development of the case, and it's something the VA is responsible for doing. You also have the chance to submit additional evidence and argument, even if the VA doesn't ask for it. But basically, the first thing that's going to happen after you file a claim is there should be some sort of development of the case. If the VA doesn't have enough information to allow for the development, they should ask you for that. And then hopefully when you give them what they need, they'll be able to do that development. When the VA has finished its development of the case, after they've gotten any exams and results from that, the next thing they're supposed to do is make a decision in the case. Decision is called a rating decision. And the rating decision is something that's going to be sent to you by mail. Gives you an explanation for what the VA decided. So whether they're granting your claim, whether they're partially granting the claim, or whether they're denying the claim. There's usually a cover letter, and then there's a more technical looking document, which is itself the rating decision. And that often lists other benefits you're already getting. Once you get a decision from the VA, you have a choice, and you can decide to accept what the VA has done, or you can decide that you're unhappy with the decision and you can decide that you'd like to appeal the decision. We'll talk a little bit more about appeals in a moment, but first, just to go over that there's generally about a year that you have an opportunity to make an appeal from the date you get notice of a decision. So that's always something to keep in mind when you get the decision, that you want to be thinking, I've got a year to make an appeal if I want to do that. So let's talk a little bit about how appeals work. So the important thing I want to start with is that there's been a recent change to how appeals work. So back before 2019, so just 4 years ago, there was a special process for doing an appeal. And I'll talk about how that works. That's currently called the legacy appeal system. For appeals that were filed after February of 2019, there's a new system for appeals that's called the AMA, and I'll go over how that works as well. So the way it worked with legacy appeals is there was a 3-step process for doing an appeal. Step 1 is you had to file something called a notice of disagreement with the VA. So that's when you told the VA that you disagreed with the decision that they made. After that happened, the VA would send you something called the statement of the case, and that would sort of give further explanation for the decision. And then you'd have a period of time that you had to submit something called a substantive appeal. The substantive appeal, also called a Form 9. So if you have an older case where you started your appeal before 2019, before February of 2019, these rules still apply. If you finished an appeal, it would go to one place and one place only. That's the Board of Veterans Appeals. The Board of Veterans Appeals would then make a new decision in the case. They could either grant the claim, deny the claim, or what's called remand the claim. Basically, if the board remanded the claim, it would be sent back to the local regional office for them to make a new decision after doing some additional work on the case. And if the claim remained denied, it would go back to the Board of Veterans Appeals. If the Board of Veterans Appeals denied the claim, you had a few choices. You could ask for it to be reconsidered, but basically your only option if the board denied the claim was to appeal it to the next higher level, which was called the Court of Appeals for Veterans Claims. Court of Appeals for Veterans Claims is not part of the VA, but they do have the ability to review the decision that's been made. And if it wasn't done correctly, if the VA didn't follow the rules, they can send the case back to be redone. So that's kind of a basic idea about how the legacy system works. Again, that applies to appeals, and that applies to appeals that are filed before February of 2019. A little bit of information about some of these things as well. And just noting again that in the legacy system, if the Board of Veterans Appeals denies a claim remands a claim, and then the regional office makes a new decision and it's not a full grant, it would go back to the Board of Veterans Appeals. That means that the Board of Veterans Appeals retains jurisdiction over claims. The new system is called the AMA, and that's the new appeal system in effect for appeals that are being filed from February of 2019 forward. Under the new system, instead of having one place you can appeal a case, you have 3 different options to do an appeal. They're still due within a year, but you have 3 different ways you can do it. The first way you can do it is you can still do an appeal to the Board of Veterans Appeals. If you do an appeal to the Board of Veterans Appeals, it will go straight there. You don't need to wait for a statement of the case and then file a substantive appeal. You just need to file the one form and it should go to the Board of Veterans Appeals. The 2 other kinds of appeals that you have an option to file are called a supplemental claim or a higher level review. And what these do is they give you an option to have things decided again at the local regional office without having to go back to the Board of Veterans Appeals. A supplemental claim is filed if you have new evidence to submit. A higher level review is filed if you don't have any new evidence to submit, but that you think that the VA did the case, made the decision incorrectly and didn't follow the rules or somehow didn't consider all of the evidence. The great thing about the new system is that under the AMA, if you get denied, no matter where you get denied, you can always file another appeal within a year. And if you eventually win the case and you don't break that chain at all, you will eventually get your benefits all the way back to the start of your original claim. Under the legacy system, if you lose your case, you got to start all over again from the beginning and you lose your effective date. So that's pretty much important to think about when you are deciding or when you think about how these different appeal systems work. There's an opportunity for folks who are in the old system, which is called the legacy system, as you recall. There's an opportunity for you to sometimes opt in and switch and become part of the AMA. And some of the things you should consider when you do that is this going to give you a better opportunity to win your case? And does that give you a better opportunity if you lose your case to continue the appeal later? There are other things you should consider when you're deciding about whether to switch into the new system. And some of that has to do with how long it'll take to make a decision. Right now, under the legacy system, if you go to the Board of Veterans Appeals, those cases are taking about 4 years to get decided by the Board of Veterans Appeals. The AMA cases are currently at least 3 years before those ones get decided by the Board of Veterans Appeals. So let's go on to a little bit about some examples under the new system, under the AMA, which is most likely to be what people are going to use these days. Let me go over how those work. So a higher level review does not allow you to submit any new evidence. What will happen is you have an opportunity to have a hearing. That'll be over the telephone with someone from the VA. You can explain why you think the VA made a mistake in its case. And the person making a decision, called a decision review officer, will take what you tell them or what you write to them, and they'll make a new decision in the case. They can decide if they think that the case wasn't developed properly. They can decide to send it back to the local regional office to do some more work on the case. If they do that, that's called a higher level review return. If they make a decision and they grant the claim, that'll also go back to the regional office for them to implement the decision. If the higher level review denies the claim, you can still file another supplemental claim afterwards. We'll talk about a supplemental claim in a moment, or you can file an appeal to the Board of Veterans Appeals. A supplemental claim is different than a higher level review return because a supplemental claim allows you to submit new evidence. It's not going to go to a decision review officer for a decision. Instead, it'll stay with the local regional office. But you do need to submit new evidence when you submit a supplemental claim. And after that, the VA will make another decision. They might decide to do some more development. And after they make a decision, if you're unhappy with that decision, you can do an appeal. You can do another supplemental claim with new evidence. You can do a higher level review without any new evidence, or you can go to the Board of Veterans Appeals. The third thing we talked about was going back to the Board of Veterans Appeals. It's a little bit confusing because under the old system, you started your appeal with something called a notice of disagreement. And under the new system, they have something called a notice of disagreement as well. But under the new system, the notice of disagreement is not just the start of your appeal, it's your entire appeal. So once you file that notice of disagreement with the board, your case goes to the board. You have 3 different kinds of appeals you can make to the board. You can ask for a direct review. That means you're not going to submit any new evidence. You can submit new evidence to the board and ask them to use that new evidence to make a decision, or you can have a hearing with the board. The first option, the direct review, is the fastest one. The ones for evidence submission or hearing with a veterans law judge, those are typically taking 4 years or more to make a decision. They've actually apparently seems to have stopped working on those for the time being. And there are definitely a lot of those around from 2020 that haven't been decided yet. If the Board of Veterans Appeals makes a decision in the case, you have a couple choices. You can appeal it to the Court of Appeals for Veterans Claims if they deny it, just like you could before. If they deny it, you can also file a supplemental claim with new evidence, and that'll keep the case going. You can't file a higher level review, though, after a Board of Veterans Appeals decision. So that is what we've got for our notices of disagreement. So next, I'm going to switch gears and talk to you a little bit about what you might think about in order to try and win your case. So these are some of the elements you need under VA rules and regulations and laws that'll help you decide if you've submitted what you need to try and win the case. So for service connection, the general rule is in order to win a case, at a minimum, you need a current diagnosis. You need evidence that you had some sort of symptoms or an injury while you were on active duty. And you need a doctor's opinion that says whatever's wrong with you today is likely related to the symptoms or the injury you had in service. So sometimes the VA, when under their duty to assist you, if you file a claim, sometimes they'll try and help you do this by getting a medical opinion. But you should always be aware that you're responsible for trying to win your case yourself. So these are some of the things you might be looking at to make sure that if the VA doesn't get them for you, that you need to submit yourself. There's another set of rules called that affect cases, some types of conditions, which are called presumptive conditions. You may have heard of these. There's a list of conditions that for certain veterans, you it makes it easier to win a case. So these involve certain conditions that are caused by, your exposure to, say, Agent Orange. There are other sets of conditions that are available to get presumptive service connection for if you were a prisoner of war, if you were exposed to the Camp Lejeune water, if you were exposed to burn pits. So there's a whole list of things, and for different kinds of conditions and different kinds of incidents that happen to you in service, there's a different list of conditions. The gist and what you need to know about these is that if you are one of the veterans who is affected by one of these presumptive conditions, for instance, if you were exposed to Agent Orange, if you have one of the conditions that's on the presumptive list, the basic advantage is you don't need a doctor's opinion to say that the condition's related to service. You should almost automatically be able to win the case. Next kind of thing to think about is an increased rating. So when you get service connected for a condition, the VA is going to assign you a rating for that condition. The rating corresponds to a certain monthly payment you get. It might be 0, in which case you don't get any money. It might be 100%, in which case you get something more than $4,000 per month. The ratings the VA assigns to a person, well, they're all based upon how severe your disability is. And the VA uses a special chart called the Schedule for Rating Disabilities to determine what percentage you get for each different kind of disability. Schedule for Rating Disabilities is something you can look up. You can go online and find it. You can look up your condition, and you can see what the list is for what symptoms you need to have to get a certain percentage. So when you're trying to win a case to try and get a higher rating, what you want to do is you want to be able to look at the list of symptoms you need to have to get that higher rating, and then you want to document that you have those ratings. Unemployability is a type of increased rating. It's sometimes also called TDIU, which stands for a total disability due to individual unemployability. And an unemployability claim basically means that your service-connected disabilities prevent you from working. So generally, in order to get a 100% rating due to unemployability, a successful claim is going to have some evidence, perhaps from your doctor or a vocational expert, somebody who can explain how it is that your service-connected disabilities by themselves prevent you from being gainfully employed. You may have heard of a term called permanent and total. There are some jurisdictions which say that if a veteran is rated permanent and total, they don't have to pay property tax, for example. For VA purposes, permanent and total means that VA has determined that your condition is unlikely to improve and that you're not going to need to be called back for any future physical examinations to see if the rating they've given you is proper. But there generally isn't a way, as far as I can tell, that you can make a claim to be permanent and total. It so happens that other jurisdictions besides VA use that designation for other benefits, but it's pretty hard, and I don't know that you can even appeal a decision that you're not permanent and total. But basically what you want to be able to do to document that you're permanent and total, if that ever comes up, is you want to be able to show that your condition is totally disabling and it's unlikely to improve. Pension is a benefit that is, as I've mentioned before, it's a non-service connected benefit. So that means that you don't have to show that your service-related conditions are causing you to be unable to work. But you do need to document a few things. You need to document that you had at least 90 days of service during a period of war, and you need to show that you are unable to work any longer. So it's usually helpful to have a doctor's opinion, if that's the case, saying that you're unable to work any longer. The other thing to know about pension is that it's an income-based program. So that means if your income is too high, you don't qualify for the program, even if you served during a period of war, and even if you are unable to work any longer. So you should take a look at what the income requirements are before you make a claim. And then if you need to be able to document that your income is below the cutoff. Survivors benefits, these are some of the things we talked about before, such as dependency and indemnity compensation. Basically, to have a successful claim for survivors benefits, it's important that you be able to document that a veteran died from a service-related condition. So usually having things like showing that a condition which was already service-connected is listed on the death certificate is usually very helpful. If you don't have documentation of what caused death, you may need to get a doctor's opinion saying what that was. It's also important if a veteran wasn't already service-connected for the condition that you think caused them to pass away, that you get that information, that you get some sort of documentation showing that the veteran should have been service-connected for that condition. Okay, next I'm going to talk briefly about representation. How does that work? First thing to know is that a veteran is allowed to have representation. A survivor is also allowed to have representation. Most typically, and for many, many, many years, almost all veterans who had a representative, almost all survivors who had a representative had a veterans service organization and a veterans service officer representing them. As I mentioned before, those are organizations like Disabled American Veterans or the American Legion. All of those organizations have folks who are trained as service officers. They are trained to provide representation to veterans, and they do so for free. So you can find these folks all over the country. There are hundreds, if not thousands of them around the country. And that is someone that anyone can get to represent them. One of the things about service officers is most organizations have a policy that they're going to represent you only on all of your claims. So sometimes it gets a little dicey where a service officer will say that they are not going to represent you if you already have representation on another claim by an attorney or somebody else. That's not actually a requirement from the VA, but that is something that many service organizations have as their own policy. If you want to work with a service officer, you can find many of them online. You can find them through going through your county or your state. Like I say, they're all over the place. But the way you engage someone to be a service officer is you and the service officer sign a document called a 21-22 form. It's a VA form that you both sign, and you both agree to be, that the service organization is going to be representing you. And then that gets filed with the VA, and voila, that person is representing you. There are other ways you can get representation as well. There's another group of folks who are called claims agents. Claims agents are people who are not attorneys, but have been trained and have taken a special test that the VA administers, and they are also allowed to represent a veteran. They're also allowed to charge a fee. So most people who are claims agents are going to charge you for their representation. In order to engage a claims agent, well, first you need to find one, and they are not going to be nearly as common as service officers, but they are definitely around there. And the final thing you can do is you can hire an attorney. An attorney is somebody who is qualified through having taken the bar in their state, and they remain in good standing. In order to represent veterans as an attorney, you have to be accredited by VA. That means you need to demonstrate to the VA that you are in good standing with your bar, that you don't have, you're not suspended or disbarred or anything like that. You also have to take classes. You have to take an initial class to become accredited. It's like a 3 or 4 hour class. And then after you do that, you have to continue to take classes every couple of years to remain accredited. So, and you have to document that with the VA. If you want to hire an attorney has a slightly different form that they have to sign with you. It's called a 21-22A form. Both you and the attorney need to sign the form, and you can list on that form if you're limiting your representation to certain claims. If the attorney is going to charge you a fee, and most attorneys are going to charge you a fee, there's also going to have to be a contract you and the attorney sign, and that is also going to have to be filed with the VA. So that is a very quick overview of lots of bits of VA law. And I'm going to, in a moment, go to any questions. Have we gotten some questions? Okay, great. So I will mention again, if you've been thinking about it and you want to ask a question, please go ahead and do so. I will go through those. If you do have questions about your case in particular, like I said, go ahead, instead of asking about your case right now, go ahead and get in touch with us, and we'll give you that information in just a little while. So we had a question about whether or how you can confirm that your selected VSO has been appointed or recognized as your VSO. A few ways you can tell about that. So if you filed the form with your VSO, one way you can tell if they're recognized as your VSO is whenever you get a letter or correspondence from the VA or a decision, they're going to list who your representative is on that form. The other way you can do so is you could go and see your VSO in person. They could look up your case in something called the Veterans Benefits Management System. That's a computer-based system where all of your documents are located and you can sort of see what's going on. And part of the information that's going to be on that, and sometimes people call it VBMS. When you look at VBMS, it's going to list who your service officer is if you have one. So that should all be there. You can also call the VA and they may be able to tell you just by they can probably look it up as well. So I hope that helps. Okay, cool. Do we have any other questions? Nope. Okay. Well, that seems like that's the only question we have. So I'm going to go on to a little bit of closing remarks. One, again, just want to mention that if you are a current client, if I am your attorney or our firm is representing you, if you've got questions about your case, we've got your case manager ready to answer those for you. Give us a call, send an email to your case manager. Your attorney is happy to talk to you as well. So just go through your case manager. We're happy to go over any questions you have. If you're not a current client, but you have questions about anything in this presentation or your case in particular, we're happy to take a look at that for you. We're going to ask that you get in touch with us through one of the methods below. So you can go to our website, www.vet1010.com. You can go to email us at intake@goodmanallen.com, or you can call us toll free at the phone number below, 877-838-1010. When you get in touch with us through those different methods, you'll be put in touch with our intake team, and they will be able to answer your question directly, or they'll be able to refer it to an attorney to be able to get back in touch with you. If you have found this webinar interesting and informative, or if you think there's more stuff we should have covered, basically, we'd love to hear from you. Go ahead and contact us through one of those methods below. Let us know what you thought about the webinar. If there's some topics in the webinar that you'd like to see us address in more detail, let us know. I'm happy to do that. And knowing what folks out there want, that's really the best way for us to be able to know what to do next. So I definitely want to hear from you. So I'll check one more time to see if there are any more questions.
The only other question is, is there an opportunity for them to talk with us about their situation?
Yeah, so someone just asked if there's an opportunity to talk with one of us about their situation, and the answer is yes. So what I'd say is if you are not if we're not representing you already, just go ahead and get in touch with us below at one of those through one of those methods, and we'll have someone who's definitely available to talk to you. If you are a current client and you want to talk about your situation, go ahead and get in touch with your case manager, and we'll take it from there. So without further ado, I'm going to move along. Thank you so much for taking the time to sign up and have a little introduction to veterans law. I'm looking forward to hearing back from you all with your feedback and perhaps seeing you at a future webinar. Thanks again. Bye-bye.